Good afternoon. Thank you for tuning in. We are Tianyu and Scott, your interviewers for this session. We are privileged to have with us Ms. Blossom Hing, a director in Drew and Napier's Corporate Restructuring and Workouts Department. Blossom is well regarded for her dispute resolution and insolvency work, with notable recognitions in Chambers, the Asia Pacific Legal 500, Asia Law Leading Lawyers, and the Best Lawyers International for her work. She is also actively involved in court and arbitration work, appearing before the Singapore High Court and Court of Appeal, and handling derivative actions, contentious commercial, shareholder, employment, and other disputes.
March 2020 was a watershed period for Singapore and the world. As a response to the COVID-19 pandemic, Singapore effectively closed its borders and disallowed gatherings for work and play. Businesses in the tourism, food and beverage, events and hospitality sectors effectively grounded to a halt. The construction sector also came to a standstill as most of the foreign workers needed in construction work were confined to their dormitories. In April 2020, Singapore passed the COVID-19 Temporary Measures Act. The purpose of the act was to give temporary relief from legal action for inability to perform certain contracts. In June 2020, the Act was amended to include additional forms of relief. Today, we will discuss the following topics in relation to the Act. First, the types of contracts and requirements under the Act, the types of relief available, the applicable thresholds for winding up and bankruptcy applications, and lastly, what to expect for the assessor's determination. Blossom, could you tell us what the purpose of the Act is? And given that this is only a Temporary Measures Act, how long it will be in effect for?
Sure. As you noted in your introduction, the COVID-19 Temporary Measures Act is an extraordinary piece of legislation to deal with an extraordinary situation that was brought about by the COVID-19 outbreak. Overnight, hotels, tour guides, money changers, restaurants, construction companies, taxi drivers, all kinds of people lost their business. As the Law Minister noted, the COVID-19 Temporary Measures Act is to address economic devastation, where businesses are destroyed, lives ruined. In such a situation, you don't talk contract, you talk equity, you talk justice, and you talk about what is the right thing to do. So the purpose of the Act is to address the cash flow issues faced by those most directly affected by the COVID-19 outbreak. The Act defers contractual obligations and prohibits legal enforcement actions for breach of contracts for a temporary period. The Act was passed in April 2020. It applies for an initial period of 6 months up to 19 October 2020 and can be extended for another 6 months. The types of contracts which are protected under the Act are as follows. First, events and tourism related contracts. So some examples will be venue and catering for weddings, for cruises, hotel packages, hotel accommodation, bookings. In some of these situations, one party might have paid a deposit and then COVID-19 struck. What happens to that deposit? Because the event can no longer carry on. So that issue of deposit can be addressed as part of the assessment to be determined in respect of the rights between parties under the Act. Second type of contract, construction contracts and supply contracts for construction materials. So for example, there's a contract to supply sand or concrete or some other materials for a construction project. But all these materials cannot come in now because of the lockdown that we had. So what happens to the rights of parties as the owner of the construction project and as the construction contractor who's supposed to carry out the works? The third type of contracts are leases and licenses of non-residential property. So for example, your rent, your leases for office premises, for retail units in your shopping center, and also say your factory premises, because there is essentially a shutdown of all these use of these premises, do you still have to pay rent? The fourth type of contracts are loans by banks and finance companies to small and medium enterprises, so what we call SMEs. Well, if you cannot carry out your contract, if you cannot carry out your business, do you still have to pay your mortgage to the bank? So the protection, therefore, is not just for tenants. Landlords themselves can be protected as well, because I could be a landlord in the sense that I took a mortgage from a bank to buy a building. I then lease out units in that building to third parties, so my tenants cannot pay me. I also cannot pay the landlord. I also cannot pay my bank under the mortgage. Then I, as a landlord, can also apply for relief under the Act if I am a Singapore SME. The fifth type of contract would relate to hire purchase agreements for commercial vehicles and machinery for commercial purposes. So this will cover your taxis, private hire car drivers. And finally, it also covers options to purchase and sale and purchase agreements with housing developers. So for example, somebody who has entered into a contract to purchase a residential unit. Now, to qualify, not only must you fall under one of these types of contract, but your contract must also qualify under the time period. So it must be a contract that is entered into before 25th March 2020. That means before COVID-19 outbreak really became so serious, where all these new directives and regulations came into effect. So contract entered into before 25th March 2020 for an obligation to be performed on or after 1st February 2020. So an example will be I enter into a lease agreement, let's say in November 2019, and it is for a 2-year period, which means I have to pay monthly rent up to 2 years down the road. So my obligation to be performed will be after 1st February 2020. So such a contract would then qualify for relief under this Act. Now there is also a final important requirement to qualify. The breach of the contract, that means the inability to pay rent, for example, which qualifies as a breach of the contract, must to a material extent be caused by COVID-19, right? And if you are able to show that it is because of COVID-19 that you cannot perform your contract, then you can apply for relief. And if you cannot agree with your counterparty, so if I'm the tenant, I cannot agree with my landlord, is it caused by COVID-19? Then you can apply for a determination to be made on that issue. And you apply by filing a notification for relief and serving it on the other party. Now, the notification for relief is a very powerful tool. Under the Act, once a party to a contract serves a notification for relief on the other party, then the other party cannot do anything. So let me give you an example. If I'm the tenant and I say, let's say I'm a tenant, I'm a money changer, right? So I have a small little shop in a shopping center in Orchard Road. Most of my customers are actually tourists. And overnight, tourists are stopped from coming into the country. Nobody is going out of Singapore either, so nobody really needs to change money. So I can't pay my rent. And under my lease agreement, if I cannot pay my rent, my landlord can boot me out. And I try to tell my landlord, well, I can't pay because I have no business. I'm affected by COVID-19. If the landlord disagrees, then the landlord can go to court. And to stop the landlord from doing that, I just served a notification for relief on the landlord, in which event the landlord cannot do anything. So the landlord cannot apply to court, cannot sue me in court, cannot apply for a writ of possession to boot me out of my unit. Basically, it's a moratorium on any enforcement action. And in the meantime, parties can then talk and try to decide, what do we do? the idea is to try and work it out. If they cannot work it out, then one of the parties can then apply for a determination. So an assessor will come in, it's a third party, to determine, okay, is this caused by COVID-19? And if it is, then the reliefs under the Act will come into effect so that nothing can be done until the period expires, which is 19 October 2020.
I'm sure a lot of our viewers are curious as to what material means. As a business owner, how do I prove that I've been materially affected by COVID-19?
Yeah, that's a good question, because it's not a hard and fast rule. It's not an objective test. It's not, there's no percentage that's given to what is the meaning of material extent caused by COVID-19. So the assessor will determine that. And to help the assessor determine that, the assessor can actually ask for a lot of evidence, a lot of documents that will help with determination of the issue. So some of the documents that can be asked are, for example, bank statements of the tenant. So back to my money changer example, I can ask for the last 6 months or last 12 months bank statements of the money changer to see how much cash is available. So to determine can or cannot the money changer pay his or her rent. The assessor can also ask for profit and loss statements. So, for example, the assessor can ask for profit of your cash inflow, profit and loss for the months of April, May 2020, and also for the months of April, May 2019. So you compare the two relevant periods before and after COVID to determine whether the loss of income or loss of cash flow is actually caused by COVID-19. The assessor can also look at past conduct of parties. Now, the Act is not meant to help failing businesses. So if, for example, this money changer is not a very good money changer, right? He's really, nobody wants to go and change money with him because his rates are just completely out of whack. The Act is not meant to help that. So the Act really is to help businesses that are affected because of COVID-19. So if in the past, this money changer has not been able to pay his or her rent because it's just not making money, and if the documents show that, then the assessor will determine, well, actually your inability to perform is not caused by COVID-19. It's just because you're not a very good business person. Then the Act will not apply.
So let's say that I'm the owner of a shop house and I've leased it out to a business. What happens when my tenant serves a notification on me and does not pay rent? How does the government protect me as a landlord who also has to pay my mortgage to the bank?
That's a very relevant question, because the Act is not meant to just protect tenants and leave landlords hanging, out there. First, landlords also can enjoy protection under the Act because your loans from banks to Singapore SMEs are covered as one of the contracts that to which the Act applied to. Right. Second, in June of 2020, so June of this year, the Act was amended to provide rental relief framework for SMEs. So the rental relief framework essentially provides for mandated equitable co-sharing of rental obligations amongst the government, landlords, and tenants. So three parties. What it does is the government, through the tax authorities, will provide cash grants to qualifying property owners so that they then basically receive a cash grant to cover the rental that the tenant cannot pay. At the same time, the landlords and occupiers are then asked to provide rental waivers as well to the tenants. So you have the government contributing, you have the landlord contributing, and of course you have the tenants being still obliged to pay the rent. Now, landlords who cannot provide enough rental waivers can also inform the government, well, I can't do that, and show why. And if that's the case, then they will be required to only provide a lower amount, or they will be allowed to provide a lower amount of rental waivers, so that it tries to come to an equitable situation where everybody contributes a bit to deal with the situation. The main aim of the Act is to find a just and equitable solution to this extraordinary situation. So in a sense, everybody chips in a little bit, everybody takes a bit of a hit, and hopefully everybody can come out of this very, very grave economic situation and survive the whole pandemic.
Now, what happens if my business is still suffering and I have creditors trying to wind up my business? Is there anything in the Act that can help me stay afloat longer?
Yes, the winding up and bankruptcy provisions, winding up under the Companies Act, bankruptcy provisions under the Bankruptcy Act have been modified as a result of the COVID-19 Act. So in the past, if you as a business owner, you cannot pay or the business cannot pay its rent, and debts are chalked up as a result, if any debts that exceeds $10,000 will entitle a creditor to apply to court to wind you up. That threshold, the monetary threshold of $10,000 has been increased for companies from $10,000 to $100,000. And for individuals, in order to file a bankruptcy application, it used to be $15,000. The debt must be $15,000 or more, has been increased from $15,000 to $60,000. So it is more difficult now in the sense that the debt must be much higher in order to file an application for winding up and also for bankruptcy. The second thing that has also changed is the period for statutory demand. So previously, it's difficult for me to show that you cannot pay your rent or that you are insolvent and therefore you should be wound up. What creditors would do is to file or issue a statutory demand, and basically it's to give you 21 days to pay up. If not, then the law will presume that you are insolvent and unable to pay your debts. Now that 21-day period has been extended to 6 months, and so basically it's a much longer period for debtors to satisfy the statutory requirements under the Act.
Moving on to more procedural questions. If I were to make an assessor's application, what can I expect?
It's actually very interactive in the sense that you will be asked to provide information and documents. So for example, the bank statements, the profit and loss statements that I had mentioned previously, you should have all of that ready together with the copy of your contract. And first, it starts off with the notification for relief, I had mentioned previously as well. And then after that, you make an application for determination, attaching all these documents, your contract. If you have your bank statements, do attach that. It's easier for the assessor. If you have documents to show that, well, actually my inability to pay is because of COVID-19, then again, attach those things. The assessor will look at the documents, and if the assessor has more questions, the assessor will then ask both the applicant as well as the respondent to provide answers and with documents sometimes, and then an assessment will be made.
Will I be able to file for an appeal if I'm not happy with the assessor's determination?
I'm afraid not. The determination is final, so there's no there's no appeal, so to speak. But if circumstances change, it doesn't mean you cannot file again for assessment. And most assessors, I understand, will say that, well, parties can come back again if there's any change in circumstances.
All right, thank you, Blossom. We have now come to the end of this segment. I hope our viewers have gained much insight on how the government has used the COVID-19 Act to aid those affected by the pandemic. With that, we conclude this installation in COVID Conversation with Lawyers series. Thank you.